Welcome everyone to our webinar on understanding your franchise compliance obligations. My name is Annalise Catania and I'm a senior lawyer in LegalVision's franchising team. And today I'm joined by Olivia Locascio. She's another lawyer in our franchising team here. Before we get into it, a couple of quick housekeeping items. You'll receive a copy of this recording and the slides after the webinar in your email. Throughout, if you have any questions, please feel free to put them in the chat box and we'll get to them at the end. And otherwise, on the completion of the webinar, you'll be sent a survey. If you could complete that for feedback, that would be great. As an attendee, you'll also receive a free consultation with us. You can discuss how we can help you with any of your franchising needs, any general legal needs as well. So if you pop your contact details in that survey, we'll get in touch in relation to that free consultation. So today we'll be going through a few things. At the start, we'll be going through your annual obligations as a franchisor, a general overview of these. We'll go through the unfair contract term laws and what you should be aware of as a franchisor, as well as considerations for renewing franchise agreements, particularly in light of some legal changes, general obligations for new and existing franchisees, as well as some other areas of law we've seen popping up that may affect you as a franchisor, such as privacy and PPSA law. I now pass over to Olivia and she'll take us through some of those annual disclosure requirements.
Franchisors with a disclosure document are subject to annual disclosure obligations as required under Clause 8.6 of the Franchising Code of Conduct. The code requires franchisors to update their disclosure document and key fact sheet regarding any changes to the franchise network within 4 months of the end of each financial year, in other words, by 31st of October. Both your disclosure document and key fact sheet must be updated every year to ensure it reflects the full franchise system. And a failure to update your disclosure document and key fact sheet may result in civil penalties. There are additional annual disclosure obligations for franchisors that operate a marketing fund. A marketing fund is a pool of money that each franchisees, and in some cases the franchisor or its associates, all contribute to in order to pay for marketing and advertising efforts done on behalf of the franchise network. If you operate a marketing fund, you must, by no later than 3 months after the end of the financial year, provide an annual financial statement detailing all of the fund's expenses. The statement must include sufficient detail in regards to the income received by the fund and the expenditure of the fund, as well as an audit of the financial statement by a registered company auditor. Once you have your financial statement and audit, you must provide all franchisees who contribute to the fund with a copy of the financial statements and the audit within 30 days of preparing the documents. There is, however, an exception to the audit. You don't need to provide the audited financial statement in respect of the marketing fund if 75% of the franchisees who contribute to the marketing fund have voted and agreed. The marketing fund financial statements must provide a clear breakdown to franchisees as to exactly where money is being spent. It is not enough to include broad catch-all categories in the expenditure associated. For example, if you spend money on AdWords, it is not sufficient to simply state AdWords. You should, for example, provide details of which AdWords were purchased, who the intended audiences was, and for what territories. Ultimately, a franchisee should easily be able to view the financial statement and have a clear idea as to the exact marketing functions that have occurred in the previous financial year. A failure to comply with your marketing fund requirements may also result in civil penalties. Depending on the information you fail to disclose to franchisees, your failure to comply may also be considered misleading and deceptive conduct, which may result in further financial detriment to you, including compensation in the form of damages under the ACL and or giving the franchisees rights to terminate the agreement in limited circumstances. There are certain financial disclosure obligations required by the franchisor to undertake and provide to their franchisees. Every financial year, a director of a franchisor must provide a written statement that the company is solvent, i.e. able to pay its debts when due, and either obtain an independent audit report and sign a statutory declaration. Please note that this is required if the company has been operating for under 2 years, and if the company has been operating for over 2 years, this is optional. On the other hand, the director may opt to attach copies of the financial statements for the previous 2 financial years. Your entire disclosure document must be reviewed and updated. However, particular information to be aware of is the number of franchisees and corporate-owned franchise businesses, updating the franchisees' contact details, events of franchise agreements ending, such as the businesses bought back by the franchisor, and those that cease to operate. All estimated costs and fees in the operation of a franchise business, ranging from establishment costs to recurring costs, any current proceedings or litigation involving the franchisor or any associates, details of any associates, for example, corporate-owned stores, supplier companies or IP holding companies, any changes to IP ownership, for example, the registering of new trademarks, any new arrangements for payments to recruiters or agents, and any additional details of rebates or financial benefits obtained by the franchisor and franchisees.
I will now, in addition to those annual obligations which fall under the code, there's quite a bit of consumer law that will apply to you as a franchisor. One of the terms that you've probably heard is unfair contract terms. They've been thrown around a bit lately where new legislation has come into force and it is effective now. Basically, unfair contract term laws apply to any standard form contract. What that means practically is really an agreement that you set the terms for and you don't allow too much variation of. And if one party to that contract is a small business, the definition of small business is quite large now, and I can't imagine many franchisees would not be deemed a small business. So you would likely be looking at all of your franchise agreements, possibly some of your licensed occupiers or any other ancillary documents falling in what's called a standard form contract. So therefore, these unfair contract term laws are going to apply to you. You might be asking why you should really care. The biggest change that we've seen come in and why people are talking about them is the penalty has now been increased. So the maximum penalty for having an unfair contract term in any of your contracts that fall in standard form is now $50 million. We obviously haven't seen this in practice, so we can't comment as to what the courts are likely to actually enforce, but it's definitely something we're recommending all franchisors have any standard form contracts reviewed in light of these laws to make sure anything that may be on the fence or a bit of a grey area is watered down or removed to try to avoid being deemed an unfair contract term. The kind of definition of what an unfair contract term is can also be quite ambiguous. The ACCC provides guidance and there has been quite significant case law, specifically last year the Phillips case. But as a general rule, really, it's if a term is advantageous to one party, gives a significant advantage to you as the franchisor, and isn't necessary to really protect a legitimate interest, and it would cause harm to the other party. In the context of franchising, this may happen with extremely broad indemnities. Say if you're indemnifying, the franchisee is indemnifying you for basically anything, and there's not a reciprocal indemnity in there. It can also occur in the context of referring to documents that aren't provided to the franchisee where they're signing. So most typically, a manual or an operations manual may be referred to in your franchise agreement. You might not be giving that to the franchisee when they sign up, and that's likely to be deemed an unfair contract term if you're trying to have them bound by that document that they haven't seen when signing. The laws, as I've said, are currently in place, and so they do apply to any contracts that you may enter into now. So from, it was 9 November, so any franchise agreements or other standard form contracts you enter into, renew or vary will be affected. So in addition to those financial penalties you may receive, there are quite broad obligations now on the ACCC. They have a lot of rights. They can, for example, just deem these unfair contract terms unenforceable and have them struck out of all of your agreements. So that's another thing to keep in mind as well. Definitely something to be aware of. Where it does apply to renewals as well, I will pass over to Olivia to go through some other things you should be aware of in renewing your franchise agreements this year.
After you've conducted your annual update of your disclosure document and key fact sheet, remember that you also need to update the franchise disclosure register. If you haven't done so yet, you must create a franchise profile on the franchise disclosure register with your MyGov ID, and you must obtain authorization to act on behalf of the ABN of the franchisor for interactions with the Department of Treasury. As a franchisor, you may choose to upload your disclosure document, key fact sheet, and franchise agreement to the register, but if you choose to do so, ensure you redact all personal information, commercially sensitive information, or information that relates to a particular franchise. For franchisees that are operating their business on a 3-year term and have entered into their agreements in 2021, they are likely to be up for renewal next year. If so, as per the Franchising Code 2021 updates, franchisors are unable to charge further legal costs upon entry into the franchise agreements on or after 1 July 2021. The only fee that is applicable to be charged by a franchisor is a renewal fee if you have one. Under the Franchising Code, franchisors are subject to other non-annual disclosure update obligations. These include remaining in good faith in all dealings with prospective and current franchisees, providing the information statement within 7 days of receiving expression of interest from a franchisee, providing a most up-to-date copy of the code. The disclosure period from the provision of ready-to-execute documents to a prospective franchisee has extended to 14 days and not 7 days. Any deposits must be refundable until the 14-day cooling off period expires, which is the period after the franchise documents have been executed for the franchisee to exit the arrangement. Any breaches, terminations, and dispute resolution processes must be managed in accordance with the terms of the franchise agreement as well as the code. And if the franchisor or an associate of the franchisor is the lessee on a lease for a premises-based franchise, updated lease documents must be provided to the franchisee as part of negotiations for renewal terms.
Moving on to some other obligations, there are a lot under the code, and obviously we've touched on the surface here and the ones we see most. Another big area we're seeing across all law is privacy, and these privacy issues, I'm sure we're all familiar with kind of the Optus data breaches and how this has affected them and their brand. As a franchisor, you do need to be aware of these obligations as well. So all privacy obligations are really governed by the Privacy Act. It only applies to what's named APP entities. All you really need to know is you'll be deemed an APP entity if you have an annual turnover of over $3 million, or if you collect certain types of information. So if you operate in the healthcare sector and you're collecting sensitive information, you will be deemed a relevant entity. If you're contracting work through the government, you'll also be deemed a relevant entity. In general, even if you don't fall in this bracket, our advice is always to comply with the Privacy Act, regardless, voluntarily, particularly where I think the general vibe in the community is customers expect to have their private information dealt with in a certain manner, and they will start to ask questions about these issues now. As a franchisor, then, we do advise that you have a privacy policy in place. So a privacy policy on your website or wherever else you are collecting information from third parties. That includes recruiting franchisees, customers, those kind of things. You should also have a collection notice, just setting out how you're collecting that information as well. Those kind of the external policies that you should put out there, really as a protection in-house and to mitigate ongoing risks. We recommend that you put in place a data management process and governing policies that set out how you're going to respond if there is a data breach. Whilst if you're not an APP entity, you're not as strictly regulated as to how you respond, there are certain processes they suggest. So it's definitely worthwhile having that in place. If something were to occur, You already know what to do. You're not trying to call someone at the 11th hour and work out, how do we respond to this? We think our client information has gone missing or been leaked. Another really important topic is providing training to your franchisees in relation specifically to privacy. We would suggest this is done at the onboarding process and even in your ongoing conferences and meetings, just providing the updates as you receive them from your lawyers or as you become aware of them. So they're receiving the same information as you, and they're not unknowingly breaching these laws and causing possible brand detriment. As I'm sure we've all seen, privacy breaches don't really result in good results for the company that's subject to them. We also recommend that a lawyer reviews all of your privacy policies and anything you have internally to make sure that they are legally compliant. And we would suggest franchisees have their own privacy policy, whether that's something you have some oversight of or not, may depend on a case-by-case basis and how sensitive the information they're collecting is. Another interesting area that we see come up with our franchisor clients is in relation to security interests. So what is known as the Personal Properties Security Act. At a high level, what that act does is develop a set of rules that sets out basically the enforcement and priority of security interests, and it creates a national register, being the Personal Properties Security Register, or PPSR, because that's quite a mouthful. You might be asking, what is the security interest and why does this even matter to me? A security interest secures an interest in personal property for a debt. Now, why we are seeing this come up a bit in franchising is often franchisors, particularly in hospitality spaces, but really in all spaces, often supply goods to their franchisees. In that supply relationship, there often is a situation of money owing to the supplier or vice versa, and you may want to register what's called a security interest. What that means is you would have an interest in certain personal property of that franchisee. So if they default on debt, it's almost a mitigation tactic. So you have something to call back and hopefully, not be out of pocket if franchisees do have overdue bills. It likely will apply as well if you are loaning money to franchisees. So if you are loaning, as part of the upfront fee, whatever you like to call it, to franchisees, you may want to look at a security interest over certain personal property to secure that debt. It's not a requirement under franchising law by any means. It's definitely just something we recommend if you are having that kind of relationship with the franchisees where you're loaning them money on an ongoing basis for certain items. It's definitely worthwhile exploring if you should be securing those debts or not. If it is something you're looking at going down, we definitely advise speaking to a lawyer, getting their involvement. You generally need certain documents at a high level, security deed, basically setting out the security that you're having a secured interest in, and if there's money being loaned, a loan agreement as well. In the context of supplying goods, this may take the form of a supply agreement, but again, it just varies on a case-by-case basis. If this is something that you're thinking about, it is really important to get some advice because there are certain strict rules around registering security interests as well. So if you have debts there and you're thinking this would be really good for me to explore, it's important that you do what's called perfecting a security interest, which generally is just registering it on that security register I went through earlier, the PPSR. If you are keen for more information, definitely reach out. And we also have a few other webinars that relate to the PPSA and the PPSR that go into a bit more of the nitty-gritty of what a security interest is and securing those debts and how that can be beneficial for you. I'll now go over to Liv to go through some general tips, summarize what we've been through today.
We always recommend having non-disclosure agreements and confidentiality deeds signed by the prospective franchisees before handing over any private or business sensitive information about the franchise network. This ensures that the information remains confidential even if the prospective franchisee decides not to purchase and operate a franchise business. It's also crucial to conduct thorough due diligence to ensure that the potential franchisee is a good fit for the brand and capable of operating a successful franchise. This may include a financial background check, assessing the prospective franchisee's business experience and skills relevant to the industry, as well as their management experience, a legal background check to ensure that they're not involved in any litigation that could affect their ability to operate the franchise, reference checks to gather insights into their character, work ethic, and business acumen, evaluating the prospective franchisee's willingness and ability to participate in training programs provided by you, and lastly, ensuring that the prospective franchisee fully understands that is willing to comply with the franchising code and the terms and conditions outlined in the franchise agreement.
With that, now today concludes the main part of our webinar. As I said, if you have any questions that have arisen throughout that, please just put them in the chat box and we can get to them in a minute. Otherwise, you might find our franchisor handbook useful. You can download this in the handout panel of the webinar, or you can scan the QR code that's on the screen currently. Feel free to download that. We also have an upcoming event that may be of interest to you, preventing wage underpayment in your business. It's going to be held on Tuesday, 5 December. You can register at the link on the slide. As a franchisor, there are certain employment obligations as well. It's definitely something exploring if you're not aware of wage underpayment or tactics to try to prevent that. We will answer all those questions in a minute, but until then, we'll talk about how we can help you at LegalVision if you're interested, and our membership model.
As a LegalVision member, you will have predictable legal fees so that you can manage your cash flow and be proactive without seeking legal advice for your business. For a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits, such as unlimited 30-minute calls with our lawyers in all of our practice areas, such as franchising, leasing, and business structuring, with written summaries of key recommendations. Unlimited drafting and review of legal documents encountered in your business as usual, including all franchising-related documents, such as the franchise agreement, disclosure document, including the annual update, key fact sheet, breach notices, termination notices, all lease-related documents and licenses, and any other business as usual documents that affect your franchise network. Unlimited Australian trademark applications, excluding the government fees, unlimited employment and workplace support, including drafting of contracts, internal policies, and ongoing support, and access to our Prism portal where you can review resources, templates, and view your projects and requests in one place, options to purchase extra credit towards complex matters and ongoing disputes, which are charged on an hourly rates basis. Members are also eligible to upgrade to our work, health, and safety advisory service, which will help your business ensure it is meeting its health and safety obligations. To learn more about how membership can help you, request a free consultation when the survey appears at the end of this webinar.
Perfect. So we've had a couple of questions come through. The first one is, what are the legal and financial requirements of franchising a business? Quite a few. We've touched on a lot of those today. Really, to answer this at a high level, as a franchisor, you're subject to the franchising code of conduct, which is that industry code. There's a whole heap of regulations under that. The ones Olivia spoke to earlier being your annual updates, providing certain disclosure documents to your franchisees, and really just generally complying with the dispute processes that are set out within that code. There are evidently some commercial laws that apply as well. So the Australian Competition and Consumer Act, misleading and deceptive conduct is a big one we see come up. So making sure you're not engaging in that kind of conduct as well. Financially, definitely something there's not necessarily a financial requirement per se beyond that disclosure that we've set out. So, having audits conducted and making sure you're solvent. but something you can explore with your accountant and see if it's a feasible model for you. There are evidently a breadth of other laws that may apply, so definitely feel free to book in a consult if you want us to address a bit more holistically everything, but they're the main ones that we always bring up first. We've also had, so do rules codes apply to master franchisors when they have a master franchisee in place? Yes, they do. So the definition of a franchisor under the code is quite all-encompassing. So it's really just anyone who grants rights to a third party to use your IP, follow your systems and processes, and market in a certain manner, or there's rules around marketing where that master relationship is likely to fall into that. All of these same codes will apply. There's not a separate code for master, but the same code in Australia will apply. Unless, of course, you're looking at going overseas, and that's something we can explore in more detail down the track, where laws do vary based on the jurisdiction.
We had another question come in about whether a franchisor can hold a sum of money as a retention fee. Yes, they can. There are a few options that are involved with the security retention amount. This is either taken at the start of the franchise relationship and refunded at a certain point, or this is also can be taken later down the track as well, and can be stored for the duration of the term and refunded at the end. A few options there, and be more than willing to discuss what that looks like on from a franchisor perspective. We also had another question about when it was mentioned about providing an operations manual before signing, and whether it needs to be provided to prospective franchisees as part of the same suite of documents that include the disclosure document and franchise agreement. The operations manual is actually not a legal document in nature, as it contains the do's and don'ts of the actual, goods or services that are being provided in the franchise network. Whilst we can give general advice as to what we think from an outside legal perspective of what should be included, it's really just about, what's involved in the business, what equipment's required, who are the list of suppliers are, and things like that. So it can be provided at any time, but really it should be provided as soon as the documents are signed, because it's confidential information about the franchise network. So if it's going to be provided before any franchise documents are signed, then at least a confidentiality agreement should be signed.
Yes, I think, to go into that more, definitely it's something that we're seeing most of our franchisors ask us about. In light of the unfair contract term laws, it should be provided before the franchise agreement's signed, but definitely having an NDA signed before that, just to avoid that. Now, that being said, just because that's our recommendation based on what we've seen, doesn't mean you might take that risk. We haven't seen how these laws are going to play out in court, but there isn't the requirement to provide it like a disclosure period or anything like that, where this is a kind of an obligation arising from common law, not from the code necessarily. And then we've had one about our membership actually. So a brief idea of LegalVision membership pricing. How does this work and differ from a traditional law firm? Pricing is really hard for us to go into. We're not the pricing people. We do all the legal work, and we have a very well-versed team who can discuss like pricing in the free consultation. Really how it works and differs from other law firms is it's a set fee that's billed monthly, and it's fixed at that. So you're not looking at every time you have a question, getting a new quote or paying an additional fee. It's just that set fee. You have access to, for example, myself and Olivia, but also to, for example, really bespoke trademark advice, our corporate team who can assist with all of those wonderful PPSA obligations and are dealing with that every day. So it's more about we provide that fixed cost certainty, and you have that unlimited LAC access where you can book in calls with us. We've also had a question just about the changes that came into place in 2021. There was a bit of a code overhaul there for most franchisors may have heard of that. Did you just want to go into that, Olivia?
Yep, absolutely. So 2021 saw significant updates to the franchising code that impacted most franchisors, particularly if they had agreements that were entered into after the 1st of July, as mentioned before, about the information statement and key fact sheet. Some other things that are really important to remember is regards to dispute resolution procedure. So references to a change now from mediation to alternative dispute resolution. And multiple franchisee parties are now able to agitate disputes concurrently where the disputes are similar. But should be aware that this is also now an exception to confidentiality, as franchisees have a legislative right to discuss the disputes with each other where this provision applies. But these dispute resolution provisions take effect for all disputes which arise from 2nd of June 2021, even if the franchise agreement was entered into prior to that date. Some other really important updates that occurred to the franchising code of conduct in 2021 include termination rights, so including, specific to calling off periods, which means that if a franchisee's business is sold without a new franchise agreement being entered into, the new franchisee may terminate within 14 days or when commencing to operate the franchise by written notice to the franchisor and old franchisees. There's also including special circumstances for termination, so an early termination proposal as well, where a franchisee may propose termination at any time, but providing written notice setting out the reasons for the proposed termination, as well as immediate termination. So the prior grounds for immediate termination now have a 7-day written notice for the proposed termination and the ground for it.
We had another one. So can franchisors provide a profit guarantee to prospective franchisees? Look, you certainly can as a franchisor. There's just a few things to be aware of. So where you are providing profit guarantees, it depends how that looks. I've seen it take many forms. Say, for example, you're saying you're going to make this amount. You need to look at realistically, what is that figure based on? Is there any element of misleading and deceptive conduct there? You can't just kind of pick any figure that you want and say, I think you're going to make this, without having real reasoning and real evidence to back up that representation you're making. If you're having it as a contractual obligation as well, it may be worth exploring, are you willing to top up how much they're making to get to that profit guarantee amount? It's often something that we would advise is the safer risk. Just where if you're telling a franchisee you're going to make this much amount, you should be really certain and confident that they will. So definitely being able to offer that top up is sometimes incentivizing and does mitigate some of that risk as a franchisor. All of this is on a case-by-case basis, so definitely worth understanding exactly your situation and the type of profit guarantee you're looking to offer, where I've seen probably 5 or 6 different types, and then approaching that in the best way. It can be done. There just are evidently some risks that we can explore. And we'll just, on the back of that, if the franchisor offers a profit guarantee they do not honour, what are the penalties? It really depends on that situation. If it's something you're disclosing in your disclosure document, you're likely to have those civil penalties under the code for breaching the code, which is about 188 per penalty currently. Then you're looking at penalties under misleading and deceptive conduct, where if you mislead them into believing a certain amount, they say, I relied on this, there wasn't evidence for making that representation, and those are the damages that can really blow out. But definitely something that's very dependent on a situation basis. But they're kind of the 2 areas of penalties you're most likely looking at receiving.
We've had another question relating to the code updates of 2021. So what happens to my old franchisees that signed onto franchise agreements before the 2021 changes? Should I look into going back and amending those old franchise agreements? Would they need to go through another disclosure period or cooling off period? If those franchisees have been entered into before the 2021 code updates, it's fine to have their agreements as there are. It's just as long as your template franchise agreement that you use for franchisees going forward has been updated as per the 2021 code updates, which would involve then, once those franchisees had entered into those agreements prior to the 2021 code updates, if they're going to enter into their renewal term or additional term, if that's an option, then they would then move on to the newer template then with the 2021 code updates. And then it would follow process of another disclosure period and cooling off period, which is process for any new agreement that's been entered into. So as long as your template franchise agreement has been updated, then there's no need to make any changes to any prior agreements.
So another one, if a franchisor agrees to deferred payments and wishes to take a guarantee and security, are there any additional financial laws that may apply? It depends on the type of guarantee and security we're talking about. So deferred payments, if we're looking at security interest, it's that Personal Property Securities Act that I went through. So if we're purely looking at deferred payments, not loaning money, that's the main piece of legislation. And in most cases, that is all that will apply if you're taking that security. If you're looking at kind of loaning money to franchisees, then another set of laws may apply. So that's if you're looking at kind of upfront saying, I'm going to loan you the amount of the initial franchise fee or the upfront fee or whatever you want to call it, then you're looking at a whole breadth of laws called under AFCAR, so the Australian Financial Commission, that have a whole breadth of things where you're a credit, possibly a credit institution, and you're governed by those laws there. So we've had another question about what should I know about misleading and deceptive conduct generally in a franchise system. Really, you know, I know I mentioned it in the profit guarantee situation. We do have a webinar specifically on this as well, so I'll go through it at a high level. Really, it applies because of that Australian Competition and Consumer Law. It's set out in there that no business is able to engage in misleading and deceptive conduct or mislead or deceive someone else in the course of business or supplying kind of services. You know, that's obviously a bit of a mouthful. What that really means in practice is you should not engage in conduct that is likely to actually mislead someone without having grounds to do it. And I think that's the important part of misleading and deceptive conduct to understand as a franchisor. It's not any representation you make or any comment you make. It's just making sure that those comments or representations are founded in fact or a reasonable basis for that belief. And generally, you will be okay. It's more so if you're making off-the-cuff comments, like I think this will be the best, you know, site in all of Australia, and you don't have any reason for saying that, that's likely to be misleading compared to something founded in fact if you're looking at the past figures of a franchise in that site, for example.
Okay, we've got time for one last question, which we have here, which is based on, do you recommend having a premises criteria for any premises-based franchisees? This is completely at the franchisor's discretion. They don't necessarily need to have a premises criteria. But if the franchisor does choose to, they would normally include specific criteria, for example, minimum, maximum square meters, local demographic factors, or to be located in a shopping centre or high street. There may also be industry-specific premises criteria as well. So like, you know, weight-bearing flooring for fitness franchises or access to gas outlets for food franchises. And then at the same time, without needing to put specific premises criteria, you know, the franchisor might decide to say that it considers, you know, whether a similar business has previously operated from the site, the demographics of the territory or local marketing area, any local competition, the street as mentioned before, and just any other factors that the franchisor considers relevant at that time of granting the franchise.
I think that's all we have time for today. I'll just make sure that there's nothing else pressing that's come in. Perfect. So that kind of ends today's webinar. Thank you all for asking those questions and really engaging. It always feels good. After the webinar ends, you will get a survey. As I said, to pop up, please provide us feedback. And we do encourage you to also put in those details if you're looking to take advantage of that free consult. If you put those contact details in there, we'll be in touch and can organise a consultation to discuss any specific, your specific franchising needs and how we can assist you, particularly in relation to franchise compliance. Thank you so much for joining.
To any people as well whose questions weren't answered during this time, please do reach out to us and join us for a complimentary consultation so we can go into further detail about your questions that weren't answered.
Perfect. So just remember, please put your contact details in order to kind of exploit that so we can get in contact with you. And otherwise, thank you so much for joining us today. I hope it was informative and look forward to hearing from some of you possibly.